Hello, my true crime lovelies. How are you? I hope you are well. I hope you are as lovely in life as you are in my mind. We are going to talk about Mama Donna a little more today. I want to cover some of the witnesses and some of the motion, well, the three motion and limines that Donna filed. I think they're a little ridiculous, but I want to go over them with you. And then I want to recap on two witnesses that we talked about before that I see that the state is deposing two witnesses on Thursday from the digital forensics company that we talked about. So I want to recap on that. Josiah from that company testified during Donna's motion for venue change with his data where he couldn't pivot just to have Donna's data. It was combined with Charlie's data. And also, he didn't explain, even though there was like a recommendation that Miami would be better, you and I know because that's where Donna's from, but he didn't explain in his data why, like what in the data showed that Miami would be better. There were no geotags, etc. So I just want to recap on those guys. But first, I'm going to run the intro. We're going to thank the members. I'm going to thank you for being here. Hit that like button if you like the video, and I'll see you on the other side. All right. So, as I said, the state has a deposition scheduled for the 7th, which is, August 7th, which is Thursday of this week. 11 o'clock, they are deposing Kelsey Guai, and 4 o'clock, they're deposing Josiah Roloff. They are doing that via Zoom. Those guys are out on the West Coast. And I just want to recap who these folks are really quickly. So, he's the owner and president of this company, the Roloff. Hopefully I'm saying his name right. Digital forensics from Spokane, not Spokane, I've learned, Spokane, Washington. So he is a senior forensic examiner. We heard him testify, and this is Kelsey and Gua. I told you in the video that we originally did about this, she testified at oh my god, what's her name? I just drew the caveat, Nancy Brophy. She testified in Nancy Brophy's trial. So that is who is going to get deposed. I suspect they're going to ask about their method of gathering the data. If I know Georgia, like I think I know Georgia, she's going to ask, how do they decipher from what location? Like, are they tracking geotagging? In other words, how do they know more people in Tallahassee have seen this data versus people in Miami? Like, how did they put that forth as evidence, right? How did they get to that conclusion? And then also, what does the data look like when you take Charlie out of it? What does the data look like specifically for Donna? Because I think there was so much press around Charlie, the maestro, right? Donna is getting more press because of her shenanigans. But my gut tells me there's less media, far less media when you exclude Donna. And even if you compare them, you're probably going to say, yeah, Tanika, because it's only half of them. But I don't think they share it equally, right? Like if they split it, I don't think it'd be 50% Donna, 50% Charlie. I think Donna is going to be less than 50. And so I feel like that those questions are going to be asked of them. So we'll see, because they're deposing both of them, not just one, right? Even though, well, they're both on Donna's witness list. So fair enough, you want to depose them anyway, but I think they're going to get into the nitty gritty. And then I haven't seen, and maybe you guys have, because sometimes I'm sleepy when I review these documents, a submission of a report from these guys, right? Of like actually handing over a report that they intend to review in trial. So if they're going to reference something, they need to have it submitted so that the state can have a counter to that, right? So they can have their own forensic experts review it and either confirm or deny that the accuracy of the data and the way that it is calculated. And you guys know whenever you see percentages, there's always a way, if you're not on the up and up, to tell the picture you want to tell with the percentage, right? It's how you word it. And so while one percentage may be true, then there might be a counter to that. However, if you look at XYZ, similar to what they did by combining Donna and Charlie, right? So they got the whatever percentage, I don't remember, that they presented. So we'll be on the lookout for that. I'm sure they'll ask, do you intend to submit a report? Or do you have a report that you're referencing? So, speaking of reports that they might be referencing, Kate Butler is on the, oh, hang on. Where are you guys? Kate Butler is on the state's witness list. And we had talked about Kate before. And I was asking you guys what you thought. Was it going to be about financial data? Because she has experience in that, but she also has experience in document review. I went back and watched the video where Georgia was saying she has a little bit of jello too. And in that one, she mentioned that there was a handwriting expert. So I think that is what Kate is going to do. We looked at this article before. It's about this woman, Kesha White, or Keisha White, sorry, Miss White, and her partners, her crime lab analysts, Kate Butler and Bonnie Beal. They are the recipient of every piece of questionable document evidence from FDLE's case across the state. So I think Kate is going to verify that whatever that note is that the informant now has, the script is what the state refers to it as, it was written by Donna. So I think we'll see her have a report of comparing those two, because here's what the state submitted. State of Florida FDLE lab report dated 7/21, 3 pages, by expert Kate Butler. So they're establishing her, they will establish her on the record as an expert. And I believe that's going to be the tell. Donna was up to no good. But far be it from me to disparage Mama Donna. I'm going to leave it to Georgia Cappleman. Wait. Okay, let's head into the motions in limine. This one, travel as consciousness of guilt, is what they're trying to suppress. I thought they already tried to suppress this one, but they like to repeat things. I mean, how many times did they repeat trying to get rid of the judge? So they're basically wanting this, any evidence related to, oh yeah, they did. The court denied the motion on August 30th, 2024. I do believe this is a matter that goes to the weight versus admissibility. The finder of fact, the jury, is going to determine whether Ms. Adelson was in fact merely researching a vacation, or if she was in fact seeking to avoid prosecution, or this is consciousness of guilt. Really, it's not for the court to exclude, as it is relevant and probative. And it's more probative than prejudicial, right? Which is the rule. Because let the jury decide. She's got a one-way ticket. They also have the phone call where she's talking about non-extradition companies or unaliving herself. She's lived a good life. I don't know if they're going to admit the testimony where Charlie says, in the Dolce Vita tape to Katie, if they had any evidence against us, we'd already be at the airport. Well, there Donna was at the airport with a one-way ticket to a non-extradition country. So they're alleging now new facts and known facts, but not previously argued, warrant the court revisiting this ruling. So they're coming with their hat in hand. Yes, we know you said no. Here's why you said no, but we have some new facts that we want you to consider. I don't think it changes the fact that it's a jury decision. Like, the jury can decide based on their view of Donna Adelson's credibility if she really was just taking a vacation. And I see that the state asked for the transcripts from that hearing where Donna made that statement when she was trying to get out on bond, right? It was my husband's suggestion, blah, blah, blah. So they have the transcripts of that. So I think if nothing else, if they ask her, like, "Why were you going?" and she doesn't repeat that, they'll use those transcripts to refresh her memory, like they did with Wendy. Anyway, okay, I don't know why that delights me so. So, here's the change in circumstance. Specifically during Jason Newland's July 9th deposition, Newland admitted that prior to the warrant for her arrest being issued, Mrs. Adelson was free to travel and leave the country. Okay, so he can still say that. He can say that now. That doesn't mean. Oh, the dogs are going crazy. Give me 1 second. Let me see if I could talk them down. Okay, they seem to be settling. So he can still say that and still admit that, and still have the evidence admitted that Donna had a one-way ticket, she and her husband. Um, namely, that at the time Mrs. Adelson purchased her ticket, notice the one-way part is omitted, to Dubai and Vietnam on November 7th, 2023, and traveled to the Miami International Airport on November 13th. She was unaware a warrant had been issued for her arrest, and nothing prevented her from traveling. And in fact, her warrant was not issued until November 13th. It was that morning that they signed the warrant. And because who is it? Sanford talks about driving down from Tallahassee. They're trying to get there before the plane leaves. And in fact, they get her on the jetway, right? So it was like down to the wire. If there was some sort of accident or anything that delayed them, she would have made it. Also, the timing is suspicious, right? So it's a week after her son, I believe her son was convicted on the 7th. And then she bought the ticket that day, or maybe it was the 6th. It was very close. And then she bought it for the 13th, right? Like she was getting expedited visas, expedited passports if they weren't up to date. Like it was a hurry. It was a hurry. And there's conversations about her looking out for the grandchildren in the will on that call that she didn't hang up, right? So there's a lot of damning evidence surrounding this lead up to this vacation. I don't know about you, but when I go on vacation, I don't start making estate plans, finalizing them for my grandchild before I do, right? She has grandchildren. I only have one grandchild, but you know what I mean. Maybe you guys do. Let me know when you go on vacation. Do you like redo all of your trust for your trustees? So, additionally, Scott Radius testified at his August 21st deposition that Newland told him that there is no bench warrant for the arrest, so they can leave the country if they want. And then here we go. This was her attorney, Marisol Descalza. Descowl. Is like how I like to say it because she had that scowly face. Mrs. Adelson's then attorney advised Mrs. Adelson after Charlie Adelson's conviction that there was no warrant for her arrest and she could travel. But did she advise her to buy a one-way ticket, talk on the phone about non-extradition countries, get her estate and business affairs in order? So Miss Descalza is on the witness list for Donna, so I'm guessing she's going to be testifying about this. She also advised that she had an agreement with the state that if a warrant were issued for Mrs. Adelson, that Mrs. Adelson would self-surrender to the Leon County Detention Center. So, but if she's in Vietnam, she can't self-surrender, right? It seems like, I don't know, if you're not escaping, you would notify them. I'm not sure. I just think it wouldn't make sense on that day for them to call and say, we have an arrest for your warrant, because again, Sanford had to drive. They could have moved up to an earlier flight possibly, or taken, I don't know, a flight to Cuba. I don't know, but they could have done something in response to that, right? So that part doesn't make sense. Anyway, Donna respectfully requests that this honorable court grant this renewed motion in limine, prohibit the state from arguing that Mrs. Adelson's flight is evidence of consciousness of guilt, and for such further release as is just and proper. I say, fat chance, defense. That's what I say. Okay, then we have opinion testimony of Jason Newland and Patrick Sanford. And I also am starting to wonder, is that why they redeposed them? They were so adamant about it to elicit this kind of information. No, there wasn't a warrant. Yes, there was an agreement with Descalza, but Descalza is an officer of the court. So I would hope she wouldn't get on the stand and lie about that. But then she's going to have to testify to whom from the state did she have that agreement with, right? That they would notify them. And was that for all circumstances, right? Like they know she has the ticket and all this other stuff. That kind of changes the game. And they have the phone calls. So I don't know. All right. Defendant Donna Adelson by and through the undersigned. So on July 9th, Newland was deposed. On July 16th, Patrick Sanford was deposed. During their respective depositions, both Newland and Sanford expressed opinions on the new investigation. So this is the investigation that started in December when the informant came forward and they got the wiretaps, right? And then they got there's two cute words for wiretaps that I can't remember. Track and trace. I think they got that after the original wiretap to hone in on if Donna's lawyer's phone was in communication with Harvey's phone while the lawyers were in jail with Donna. So during their respective depositions, both Newland and Sanford expressed opinions on the new investigation. By this motion, Mrs. Adelson moves to exclude opinion testimony of both Newland and Sanford. The threshold question for admission of evidence is relevance. Florida statutes permits lay witnesses to offer opinion in limited situation. So I don't know if I would consider them lay witnesses. And I don't know if the only two things are either you're a lay witness or you're an expert, but certainly based on their years of experience, that would not make them like me going in and giving an opinion, right? My 2 cents. They're not paying me for that. But both of them individually and collectively have this vast, many years of experience dealing with these matters. So they go on about lay witnesses. However, under this exception, opinion testimony is usually limited to matters relating to distance, time, size, weight, form, and identity, which are easily observable. Montecon v. State, Florida First District Court of Appeals, 2023. So the opinions expressed by Newland and Sanford do not concern distance, size, time, weight, form, or identity. Rather, they concern the truthfulness of allegations raised during the new investigation. Allegations, the vast majority of which are not corroborated by any evidence. So vast majority, but not all. Newland and Sanford's opinion concerning the new investigation are inadmissible. Martinez v. State, holding a witness opinion about the guilt or innocence of the accused is inadmissible. Okay. Even if their opinions concerning the new investigation were admissible as lay opinions, again, they're playing with that word lay, such testimony should be prohibited as its probative value is substantially outweighed by the danger of unfair prejudice. So I don't know what they're trying to delay here because eventually this would still be prosecuted, I would think, specifically if her attorneys were involved in this illegal activity, right? Like Donna should not have been having conversations with Harvey on unmonitored lines. So if she in fact used Jackie Fulford's phone or Mr. Zellman's phone, they're in trouble too because they are officers of the state of the court. Respectfully, so she respectfully requests that this honorable court grant this motion in limine order. Enter an order prohibiting Newland and Sanford for offering their opinion concerning the new investigation during her trial and for such further relief as is just and proper. I don't know if the state was even planning on admitting this or having this, but maybe it could be used for impeachment if the judge does agree that they're a lay. We won't get to see the depositions because unfortunately under that seal order that they filed, their depositions are included. Specifically, let me just look at this. They're asking to seal the depositions of Jason Newland, Chris Corbett, Patrick Sanford, Brittany Adams, Joshua Turner, Patricia Bird, and the interviews of Drina Bernhardt, who Patricia Bird and Drina Bernhardt are the jailhouse informants, from what I understand. You guys let me know who Brittany Adams and Joshua Turner are, because I haven't had time to research that. So that is the request there. And then the last motion in limine I want to go over with you. Did I skip that? Interpretation of emails, which this, I mean, I feel like this is on a case by case basis. Actually, I think the other is too, not case by case, but question by question. Like, instead of saying none of it is allowed, object as it becomes. Like, is it speculation? Like, what specifically about it is not admissible, right? Because I think we're going to get past the layperson hurdle. We've seen it enough times, like with all your experience and blah, blah, blah. Did you derive? And people say yes. I think that's going to get us over that hurdle. They certainly would know, based on looking at all of the evidence that they got from the wiretaps, whether there's a foundation for the opinion that they came to. So I think the same is going to be true for interpretation of emails, recorded phone calls, and text messages. Now, you and I, we are lay people, well, most of us. And we definitely have an opinion and an interpretation about some of those recorded phone calls, like Donna saying they were looking for a non-extradition company. Like, I can interpret that. Thank you very much. So, and the jury are lay people. Let them interpret it. Let them come to the conclusion they will. I think you present it, and then they decide. Mrs. Adelson has been indicted. Throughout the prior trials, state witnesses have testified concerning their interpretation of one, Mrs. Adelson's emails. I can tell you my interpretation of her offering to dress the grandchildren in Nazi uniforms for their Orthodox Jewish father. Two, statements made by various parties on recordings, Donna and Charlie, Donna talking to people and being recorded because she didn't hang up, and text messages. Don't get me started on the text messages. By this motion, like the one we're outside the night of dropping off the money, by this motion, Mrs. Adelson moves to exclude testimony of witnesses interpreting emails, recorded statements, and text messages. The threshold question for admission is relevant, so they're going over the same thing. If a witness is not testifying as an expert, the witness's testimony about what he or she perceived may be in the form of inference and opinion when the witness cannot readily and with equal accuracy and adequacy communicate what he or she has perceived to the trier of fact, to the jury, without testifying in terms of inferences or opinions. So they're not letting me testify. I'm all about inferences and opinions from the facts. And the witness's use of inferences or opinions will not mislead the trier of fact to the prejudice of the objecting party. So if they said, I interpreted her looking for non-extradition countries as a way to avoid being extradited, I don't think that is an inference that will mislead the trier of fact. I think they probably are already there with that thought. And then law enforcement would confirm it. What do you guys think? The opinions and inferences do not require a special knowledge, skill, experience, or training. That doesn't. I think she was looking for a non-extradition company, so she wouldn't be extradited. That does not seem like you need special knowledge. In Thorpe v. State, the court reversed the defendant's conviction and remanded for a new trial after finding the trial court improperly permitted a witness to testify to their interpretation of what the defendant said during a conversation. Ooh, is that a little bit of a threat? Because no court wants to be reversed. We'd have to look that up. During trial, the witness was asked to opine what the defendant meant when the defendant made a statement. Now, see, the opposing party could have objected for speculation, calls for opinion. The defense objected, arguing that the question called for the witness to speculate, that his interpretation was irrelevant, and the witness was not qualified to offer his opinion. The trial court permitted the testimony. I don't think Judge Everett would make that mistake. But okay, I see where we're going now. On appeal, the Florida Supreme Court held that as a general rule, lay witnesses may not testify in the form of opinions or inferences. It is the function of the jury to draw those inferences. Since the witness was able to convey what the defendant said, the exact meaning of Thorpe's words and the inferences that may have been drawn from Thorpe's statement should have been made by the jury and not the witness. Okay, fair enough. I think that's straightforward enough, but they could read the text or read the email and leave it at that and not give an opinion. Then it doesn't prohibit them from reading about her saying to dress the children up as Nazis. Although it would be appropriate under the rules of evidence for a qualified witness to interpret coded conversations. Testimony which interprets clear conversations does not aid the jury and is inadmissible. So maybe that's also Kate Butler can talk about coded conversations. This TV is going to cost about $5, right? Or leave it up to the jury. To me, it seems clear, but they might want to put a pin on that and highlight. The TV is about $5. All the conversations about a hitman, the TV being cheaper than a hitman. I mean, it doesn't take a rocket scientist to figure that out. But I do understand we all comprehend at different levels, but I think at least one person on the jury, if not more, would get it, and they would talk about it in the jury room. Like, well, what do you think she meant by this TV costs about $5? So there's what has been entered. Let me know what you guys think. She's trying to keep a lot out. Like I said, they're doing more than what Rashi did for Charlie. So if some of this sticks, good for them. I just don't feel like any of them have a leg to stand on with what they've submitted, but we'll see what Judge Everett comes back with. I can't remember. I know she's got a trial date coming up and these motions will be heard. So we'll know soon enough. Try it one more time. Maybe their servers. There's a court date coming up and these motions will be heard then. Oh, here we go. So August 8th. August 8th at 9 a.m. is her next court hearing. So I'll cover it. I don't know if I can cover it live, but I'll definitely cover it and we'll talk about it. Because I'm here for a smackdown that I'm anticipating by Judge Everett, but we will see. I mean, we got to give him an A for effort, even if it isn't necessarily logical. Defense's job is to poke holes in what the prosecution's theory is, right? They don't have to prove anything. Prosecution has to prove it. Defense's job is to make it as difficult as possible to do so. So they're certainly laying down hurdles, or what are those things in the high-speed chases, whatever those are. And I think Georgia and team will go around them. No tires will be slashed in the making of this conviction. Let me know your thoughts down below. I'll talk to you later. Toodles.